So this matter comes before the court today regarding a request by Mr. Thomas for costs and attorney fees. The court had previously found a violation of the Public Records Act and had imposed a penalty upon Lewis County for that violation. And as contemplated by the parties throughout, once the violation was found, there had been the clear direction by the court and the parties as well that this would be the hearing that we would have to discuss appropriate, reasonable attorney fees and costs. And so I've reviewed all the materials that have been provided, but I thought it would be appropriate to give you both a brief amount of time to be able to address anything that you wanted to, and then I would go through and make my ruling. Mr. Thomas?
Your Honor, first I have a statement of additional authorities that supplements the authorities in our motion for this court.
Was that filed?
No, it's I can do it as a request for mandatory judicial notice right now, or I can give it to the court. Or
I don't understand how I'm supposed to. This is the hearing that you set, and I've prepared, so I don't understand how I'm supposed to now take on additional information.
There's no new argument, it's just additional case law.
Let me see what you have. And you haven't filed it?
No, I haven't.
Well, I'm not going to consider anything that hasn't been filed with the court, Mr. Thomas.
Okay.
I think that's something we've discussed previously.
I don't remember that, but I respect the court's decision.
Thank you.
Well, I would like to start off with what this court summarized. This court found a violation of the Public Records Act. This court ordered a penalty for Lewis County because of its violation of the Public Records Act. But Lewis County comes back in bad faith to this motion for costs and attorney's fees and says, look, we're halfway prevailing here. This is a stunning argument, Your Honor, absolutely stunning, that Lewis County was found in violation of the Public Records Act, that this court ordered them to pay a penalty. They have to pay reasonable costs and all costs and reasonable attorney's fees. And Lewis County is arguing, without any law supporting them, that they are partway prevailing. There is no law that supports this proposition. In fact, Lewis County's own case law, a lot of Lewis County's own case law that it supports, contradicts its stated position. First of all, Lewis County is not prevailing in this claim whatsoever. There was only a single claim in front of this court, the denial of the right to inspect and copy by Mr. Cortland and Mr. Green. This court unequivocally found a violation of the right to inspect and copy when it signed the order. And in fact, the order on the merits that this court signed states in paragraph 29 that there is a violation of the right to inspect and copy, and it states that Mr. Cortland and Mr. Green are the prevailing parties in this lawsuit. Lewis County doesn't state how it's a prevailing party. It states that, well, we think that we're the prevailing party because the court adopted their reasoning in the penalty stage. First of all, as a matter of law, that's not correct because it's only based on the claims. Lewis County says, well, it's an issue in the lawsuit, and they throw around this term issue. There's no support of the word issue anywhere in law. In fact, the word issue is not a term in the legal context that has any definition from the common.
Mr. Thomas, I'm going to ask that you just go a little bit slower. You're, I think, right at the edge of where it's going to make it difficult for the court reporter.
There's no legal significance to the word issue. In fact, the case that Lewis County cites and the term that they use in argument one, the heading of argument one, is a claim. A claim is a legal cause of action. And Mr. Cortland and Mr. Green prevail on every legal cause of action into this court. Lewis County's argument is not only made in bad faith, it subverts the Public Records Act, and it's flaunting the Public Records Act. This is like in a criminal case where if somebody makes a guilty plea and they're sentenced to 10 years in jail, and the person who is sentenced to 10 years in jail says, you know what, I could have been sentenced to 20, but because of the plea bargain that I entered, I had 10 years less to serve in jail. And so they said, I'm partway prevailing. That's not correct. Either you're prevailing or you're not on a cause of action. Mr. Cortland and Mr. Green are prevailing. Lewis County broke the law. This court found that Lewis County broke the law. It is stunning that Lewis County is coming to this court today and saying that they are partway prevailing. This is a harassment of plaintiffs, and this is a harassment of me, too. And then Lewis County, their second argument to this court, is that they don't have to pay all costs. RCW 42.56.550, Section 4, clearly states all costs. I'm not sure how what legal gymnastics Lewis County must do in order to read into the plain language of the statute and add words into the plain language of the statute to ascertain that all costs does not mean all costs. And in fact, even more bad faith, Lewis County is arguing that filing fees for judicial copies to this court, to your honor, should not be included in the statutory costs. The statute says all costs. This was plainly done to further this lawsuit, the filing fees. If plaintiffs did not pay the filing fees, this court would not have received the judicial copies. This court requires judicial copies. And so it is, again, stunning that Lewis County comes in bad faith and says, you know, we don't believe that we have to pay for these costs. Lewis County is flouting the law. They didn't learn anything by violating the Public Records Act.
Mr. Thomas, I have a question for you regarding your declaration in support of all costs and reasonable attorney fees. On page 3, under paragraph 5, were those typographical errors regarding the amounts that you're requesting?
Let me check.
It appeared that there were.
I'm sorry, did the court say page 3, paragraph 5?
Correct.
I have in there that it
says, I have performed 15 1/10 billable hours, and then it has a numeric 267.5, and then it states the amount of attorney fees I'm requesting is $3,775, but then there's a different amount that's put out numerically.
Yes, Your Honor, it is a mistake, and I apologize for that. So the
I assumed that you meant
yes.
that you meant 267.5 billable hours, and you meant $66,875.
Yes, Your Honor, and that's a mistake, and I apologize for
No,
that.
it's quite all right. I just wanted to make sure.
Yeah, that's in accordance with the spreadsheet that I submitted to this court.
Yes, thank you.
So I apologize for that. So I'd like to draw this court's attention to the holding in Paz versus University of Washington, and that's at 114 WN 2nd 677.
I'm familiar with that case.
Page 684, 1990. And in there, they say, quote, in Tacoma News Incorporated versus Tacoma Pierce County Health Department, and that's at 55 WN APP 515 525, 1989. The court held that the prevailing party for the purposes of the Public Disclosure Act is the one who has an affirmative judgment rendered in his favor at the conclusion of the entire case. This is what this court summarized when it started reciting to this case, what this case was about. Lewis County violated the Public Records Act, but Lewis County doesn't get that. This is in accordance with the Sanders versus State case that's in both plaintiffs' filings to this court and defendants' filings to this court. However, Lewis County and defendants pervert the Sanders versus State case and say that, look, the Sanders versus State court said that any issue in the case, whether it's a motion for a continuance or whether it's a motion to strike or anything like that, can be an issue to determine attorney's fees. And that's not correct. And they say that that can determine attorney's fees and the prevailing party status, and that's not correct. The prevailing party status is determined on the claim. In fact, Sanders versus State later says and this is quoted in plaintiff's motion, that on the bottom of page 4 of the motion, quote, any person who prevails against an agency in an action in the courts seeking the right to inspect or copy any public record shall be awarded all oh, wait, I'm sorry, that's not the right one. Oh, here it is. Quote, there is no reason why the definition of prevailing under the PRA on appeal should differ from the definition at trial. We therefore focus on the issues bearing on either the right to inspect and copy or the right to receive a response, end quote. That's Sanders versus State. And Lewis County was on notice that we were citing Sanders versus State when they wrote the response. However, Lewis County in their response says that they're a prevailing party too. They don't try to harmonize Sanders versus State with their own theory of what Sanders versus State says. Lewis County doesn't even take into consideration the plain language of Sanders versus State. Lewis County doesn't take into consideration the plain language of Paz versus University of Washington in 1999. Lewis County doesn't take into consideration Tacoma News Incorporated versus Tacoma Pierce County Health Department from 1989. There's a litany of cases, but Lewis County just violates its duty of candor to the tribunal and makes up what the standard is for the prevailing party in Public Records Act cases. This is stunning. Lewis County just cannot make up the law. Lewis County has a duty to accurately present the issues to this law. Lewis County Mr. Eisenberg can actually advocate for his clients, but Mr. Eisenberg cannot distort the law that he presents to this court, and that's what he's doing today. He's distorting the statute, he's distorting case law, and he's doing whatever it takes in order to win this lawsuit instead of presenting case law and the statute fairly and accurately to this court. It is stunning. And I will save the rest for the rebuttal.
Thank you, Mr. Thomas. Mr. Eisenberg.
Thank you, Your Honor. So I would say the first and most important point in Lewis County's responsive briefing is the same issue that Mr. Thomas is now describing, which is when the PRA case law, which imports the same standard as prevailing party case law in other respects, when it discusses the award to the prevailing party, the court has to determine to what extent the plaintiff prevailed. Since the Sanders case was brought up, I want to go right there. In the Sanders case, the court discusses the litigation below in a lot of detail. One of the issues below was what is the remedy for a violation of the, quote, brief explanation requirement. In that case, the Attorney General's office did not provide an explanation as to why it was withholding certain documents, which violated the PRA because it requires that an agency give a brief explanation as part of its response. The parties litigated about what the remedy for that violation was. Ultimately, the trial court and the Supreme Court decided that the remedy is a consideration of that factor in the penalty phase, and it did so consider that factor in Sanders' appellate case. When the Supreme Court then both analyzed the trial court's take on costs and fees and did its own cost and fee award, it treated the remedy for the brief explanation requirement as an issue in the case that was in play in terms of who prevailed. That shows that penalty phase litigation is part of the calculation as to who prevailed when deciding to what extent the plaintiff prevailed. Similarly here, the court found that Lewis County violated the PRA. Absolutely the case. Mr. Thomas is correct when he points to Your Honor's order saying that plaintiffs prevailed on that issue. We then litigated the remedy for that violation. And Mr. Thomas, on behalf of his clients, asked for a very large penalty at the high end of the range, and Lewis County asked for a much more modest penalty. The court adopted Lewis County's penalty exactly, and that order indicates that Lewis County prevailed on the issue of penalties. So, when applying the prevailing party analysis, it is appropriate under Sanders and under the Green case, which I'll discuss in just 1 second, to note that the plaintiffs in this matter did not fully prevail. They prevailed And to the extent that they prevailed, they are entitled to costs and reasonable fees. But to the extent that they did not prevail, they are not so entitled. And that's fleshed out not just in Sanders, where you have to intuit the ruling from a very detailed analysis, but in black letter law from Bowers and the other cases like O'Neill that cite Bowers as standard. That's the general prevailing party analysis. It's not unique to PRA cases. Looking at what the case was about on the litigation and who prevailed on what is exactly what the court is always doing in those cases. Now, the reason that the Green case is important is it is an unpublished case. It is not the case that is binding authority on Your Honor. However, this exact issue came up. Lewis County and Mr. Green, with Mr. Thomas as his lawyer, argued the exact same point in that case. In that case, Lewis County admitted a violation of the PRA up front. It had not provided one of the documents requested. It admitted so at the outset of the litigation, and then it turned over the document at that time. There was then a year's worth of litigation in which Mr. Green sought to establish that the reason Lewis County had not given out the document was because it acted in bad faith as part of a conspiracy to damage his chances in a sheriff's election when he was running as a candidate. The trial court ultimately found no evidence to support that allegation. It awarded a much smaller penalty than Mr. Green sought, and awarded only 25% of his costs and fees as a result of that decision, because all of the litigation essentially was about the penalties phase, not about the merits phase. On appeal, Mr. Green challenged that fee and cost allocation as being improper because, he argued, penalties phase issues are not relevant to that. Only the merits matters, and they won on the merits. The Court of Appeals affirmed Judge Hirsch's decision, finding that because Mr. Green had not prevailed on his bad faith and conspiracy claims, which represented the bulk of the litigation, it was reasonable to discount his costs and fees by to 25% of what he asked for. So this was the exact issue that we just litigated in that case. And so the Court of Appeals is interpreting Sanders to be what Lewis County is. It's not stunning or bad faith for Lewis County to argue to you that which it believes the law is based on specific rulings. So because of that, I ask Your Honor, at a minimum, not to award Mr. Thomas any fees that he's requested on behalf of his clients related to penalty phase litigation, since on the facts of this litigation, they did not prevail on that portion of the case. Once you have done that rough cut, if you will, you still have to determine what counts as a reasonable attorney's fee. And that has its own set of law, which is cited in our briefing, and it involves you looking at the hours billed and how they measure up with the work performed. Specifically, do you think it's the right amount of hours for this case? And Lewis County argues, Your Honor, that it's really a lot of hours for this case. I list sort of specific examples, but the three ones that really popped out to me were 24 hours, not 24 hours of actual time, 24 billable hours, straight full day of work on reviewing discovery materials of financial documents for Discover Lewis County, that I don't understand how those were relevant to the actual issue in this case, because any turning over of documents would have been, under plaintiff's theory on which they won, would have been a win. I mean, they were the catalyst for the production of documents. Your Honor ruled that. So I don't quite understand why he needed to look at every page of these very repetitive financial records in order to litigate. His opening brief, he spent, again, a full 24 hours of billable time on. That's a pretty long time. But what makes it most sort of apparent that that's an unusually large amount of time is that we did a continuance shortly thereafter, which is in the record and in the billing. And then in March, Mr. Thomas, by agreement, had the opportunity to file an amended opening brief. And he billed another 18 full hours to make the amended brief, and it's really, really similar to the original brief. And I also have attached a copy of the discovery, just so that Your Honor can see that it just appears to me that, although I don't doubt for a moment that Mr. Thomas may have actually spent this amount of time, that he is spending a lot of time on this case, more so than I think like a reasonable attorney in private practice would. And as a result of that, I think it's reasonable for Your Honor to reduce the amount of hours and apply the lodestar to the reduced hours. You've read my briefing about why I think $200 an hour is appropriate. You've seen the work in this case. You've seen that some of the things that Mr. Thomas filed were kind of odd, like the request for mandatory judicial notice, which Your Honor commented on in court. Why did you file that? So I think $200 an hour is appropriate. I think 59.33 hours, or about 60 hours, is would have been a fair amount for this case, and I'm asking Your Honor to award that amount. One final issue with regard to costs. There has been back and forth on Mr. Green's mileage costs, in which I mentioned that he's filming for purposes of journalism in addition to showing up as a party in the case. I think it's worth pointing out that in none of the hearings in these matters, which are of course in the record, they were before Your Honor, Mr. Green was not required to be here. He didn't testify or otherwise act in those hearings. He was here to see them because he was interested in them as a plaintiff and because he wished to film them for his coverage. And that's very laudable. I think it's wonderful. But the question is whether that's a cost incurred in the litigation that is awardable as an expense. And I don't believe that it is. I think Your Honor should decline to award that expense.
Thank you.
Thank you.
Brief rebuttal, Mr. Thomas.
Okay, Lewis County starts out by talking about the prevailing party status. First of all, what's notable about Lewis County's argument is they don't address plaintiff's argument. They don't address the binding case law upon this court that we just cited. The three different cases that clearly explain what a prevailing party is. Lewis County is subverting its duty of candor to the tribunal of the court and not harmonizing case law like they're supposed to and bringing all the case law, whether it's adverse to them or not, to the court for it to make a decision. But it's clearly just running with its own argument because that's what it believes. What Lewis County believes and Mr. Eisenberg's duty to this court are two different things. Mr. Eisenberg talks about Sanders versus State. He doesn't try to harmonize when Sanders versus State says the only two issues for a prevailing party, whether it's on appeal or at the trial court, are the right to inspect and copy or the right to receive a response. He doesn't do that. He tries to construe Sanders through his own lens in order to distort Sanders to this court. Mr. Eisenberg actually says that, you know what, they were talking about redactions, a brief redaction explanation. That's correct, Your Honor. They pled that in the complaint. They said they were denied the right to inspect and copy because they didn't receive a reasonable explanation. That's the difference between what happened there and what happened here. That went to the right to receive a response or the right to inspect and copy records, whereas here, the penalty has nothing to do with the claim. The penalty is a court-created doctrine by the Washington Supreme Court. Mr. Eisenberg is saying now that the Washington State Supreme Court is a super legislature and can impute its own definitions into the Public Records Act. There is no case law whatsoever ever holding that the Washington State Supreme Court or Washington courts can act as a super legislature. In Sanders versus State, it's clear, if this court reads the facts, that the brief redaction requirement was over the claims presented, the right to inspect and copy. Lewis County doesn't address plaintiff's binding case law. This court is left with an option. This court can accept the binding case law that plaintiffs present, or it can go with the persuasive authority that Lewis County presents. However, this court cannot overturn binding case law sub silentio. So if it goes with Lewis County's argument today and goes with a persuasive, unpublished Court of Appeals decision, this court needs to explain on the record why it is not adopting the binding case law upon this court, because otherwise it would be overturning, untenably overturning case law sub silentio. Second, Lewis County talks about the right amount of hours. And this is stunning too, because Mr. Eisenberg talks about in his opinion. And Mr. Eisenberg testifies, but he doesn't provide any evidence. I provided my evidence, I performed my duty, and there's actually binding case law upon this court that says if you're going to challenge hours as an opposing party, you need to provide your own hours. We actually even pointed that out to Mr. Eisenberg in the reply brief. It's actually been pointed out to Lewis County in other cases too. And Lewis County just ignores that like we've done everything else in this hearing today. Lewis County doesn't want to provide its own hours, but they want to criticize my hours. Mr. Eisenberg was the cause of the continuance. It actually says that in the joint motion for continuance in December, where Mr. Eisenberg didn't get the discovery to the plaintiffs on time. I had to review the discovery in order to see whether there were any other issues that would have arisen out of the discovery, whether these documents were truly, as Lewis County said, but we just forgot to produce them. Because they're saying that it was an honest mistake and that they never intended to deny plaintiffs. That had to be reviewed. In fact,
Mr. Thomas, I'm going to ask that you wind it up.
Okay. The third point is Lewis County is trying to challenge $200 an hour, and they're trying to say a reasonable rate is
I don't need to hear any argument on that.
Okay, I'd just like to point this court to my declaration, Mr. Cortland or Mr. Green's declaration establishing the $250 contracted rate with Lewis County.
I read everything.
In July. Thank you.
Well, the reason, Mr. Thomas, that I didn't need to hear any discussion about the $250 versus $200 per hour that Lewis County disagreed with you on is that I am awarding the $250 per hour. I'm doing that, and I understand there's a disagreement, and I've tried to encourage the parties to respectfully deal with one another throughout this case, but I understand emotions can run strong, but Mr. Thomas, the continued representations that you've made throughout this argument today that Lewis County has harassed you, has been insincere with the court, I don't find any basis for that. I find that both you and Mr. Eisenberg have advocated your respective sides. You've come to court, and at times, I have found that you both have been willing to work together, and I had hopes that perhaps there was a level of collegiality that has been apparent to me that at times appears to exist. But the rhetoric today causes me concern. The issue about the amount of fees for the attorney hours in terms of the $200 per hour and $250 per hour, I think is a legitimate dispute. But I agree with you, Mr. Thomas. I think ultimately the $250 per hour is the appropriate rate, and I'm imposing that rate. Lewis County cited to two other litigations involving the same parties, one in front of Judge Hirsch, one in front of Judge Lanise. But I'll just point out that those orders and those cases, Judge Hirsch's was February 28 of 2017, Judge Lanise's was January 19 of 2018, and clearly an attorney can change their rate at some point, and I am awarding attorney fees at the rate of $250 per hour as requested by you, Mr. Thomas. Now, the issue of, Mr. Thomas, you had requested a multiplier of 1.5. As the parties are aware, multipliers are a discretionary decision by the court, but they're one that the Supreme Court and the courts of appeal have repeatedly stated are rare. They are not to be applied except in truly appropriate circumstances, and I do not find that there needs to be an adjustment to the lodestar in the terms of applying a multiplier. It does not appear to me, based upon the record, that that is needed. Understanding that this was a contingent situation, but looking at the difficulty of the case, looking at the quality of the work, I believe the $250 per hour fairly and reasonably compensates you, Mr. Thomas, for that. And so I will decline to apply a 1.5 multiplier as requested. So I want to also thank Mr. Thomas that the spreadsheet was helpful. I think that is the appropriate way to put out your hours. There were, and I'm going to go through them because the court will make some adjustments. The court has to look at what are reasonable attorney fees. And part of that is also looking at the rate that is being charged. So when I'm looking at that, I guess the easiest way is to simply go through, because I went through the pleadings again and compared those to the hours that are being requested. And so when we start on August 14 and August 15, there was factual research. And between those 2 days, there was 14.2 hours of factual research. The court is imposing 8 hours for that factual research. The factual research designation is difficult because there's not much information in support of it. But, and I'll get to this when we talk about drafting the complaint, it's clear, Mr. Thomas, that your complaint was very detailed about everything. And so I'm imposing the requested amounts for the drafting of the complaint on August 15 and 16, and obviously your client communication also on August 15. Regarding the reviewing responsive PDR docs production on 9/12, 9/13, and 9/14, Mr. Thomas had requested 24 hours of billable hours. The court's analysis will be to impose 8 hours as a reasonable amount of time to go through those materials. The court will impose the requested client communication on 9/14, drafting discovery on 9/14 and 9/16. I will order the requested amount for the 9/27 GR34 order and filing complaint with the court. The October 5th review answer to complaint. The October 20 LCR 16 hearing. The 10/20 client communication. This is an appropriate time to tell you that the court will not be ordering travel time, as barring circumstances not presented in this case, travel time is not compensable in an attorney fee award. Regarding the October 22nd and October 23rd entries for review Lewis County discovery responses, Mr. Thomas had requested 15.1 hours. Again, for an attorney of his experience at the rate that he is charging, the court will order 6 hours as a reasonable amount of time to go through those materials. The court will impose the requested, all of the client communications that are requested up through May 18th, and I'll discuss that more in a moment. The December 6, December 7, and December 9, there was 3 entries there for draft opening merits brief, and Mr. Thomas had asked for 24.3 hours. The 24.3 hours, part of what the court looks at is whether hours are redundant, duplicative, and as I mentioned earlier, there is an award for factual research, there is an award of over 12 hours for drafting the complaint, and also there has been an award for drafting that opening, well, the opening merits brief has multiple entries. There's the 24.3 hours that I just mentioned that was requested, and there was a 17.8 hours requested from March 6th through March 15th. Regarding the 12.6, 12.7, and 12.9 requests, the court is awarding 16 hours, not the 24.3 that was requested, as being a reasonable amount of time for an attorney of Mr. Thomas's experience and skill to be able to draft that merits brief that, as again I stated, had been reviewed. The communications between Mr. Thomas and Mr. Eisenberg through May 18 will also be awarded. The joint motion for continuance and supporting documents, the declarations of Mr. Green and Mr. Cortland from December 11 and December 14 will be, those costs will be, those fees will be awarded in full. The response to Lewis County's discovery requests on March 6th will also be, those fees requested will be awarded in full. Then when we get to the entries of draft opening merits brief, now March 6, March 7, March 8, March 15, Mr. Thomas requested 17 hours there. The court is ordering, based upon a review of those documents, evaluating, again, Mr. Thomas's knowledge, skill, experience, and looking at the quality of those documents, the court is awarding 12 hours, not 17.8. March 15, the drafting declarations, the court is awarding those requested fees. The April 2nd reviewing of Lewis County's declarations and reviewing Lewis County's merits brief, the court is awarding those fees as requested. On April 2nd, April 3rd, April 4th, Mr. Thomas has requested 14.4 hours for drafting the reply merits brief. The court, again, looking through that pleading and taking into account all the factors I previously mentioned, the court is awarding 8 hours of attorney fees for that work, not 14.4. The April 4 draft request for mandatory judicial notice, the court is not awarding any attorney fees for that document. As
Your Honor, I don't see that on the list. Is that on the list?
It's on the list that was provided to the court.
Okay.
April 4th, 2018, it says draft request for mandatory judicial notice. Do you see that?
Yes, thank you.
You're welcome. I'm not awarding that, as that was not productive work. The April 4, April 6, and April 10 entries regarding a motion to strike and for sanctions also will not be awarded. That was unproductive and unsuccessful. The court will award Mr. Thomas his requested fees for the April 13 merits hearing, for the April 29 drafting of the proposed order, for the May 9 draft motion for presentation of order, and for the May 9 draft declarations. for the May 11th review, Lewis County's response to motion presentation, for the May 14 draft reply motion presentation of order, for Mr. Thomas's time at the hearing on May 18. And that takes us through that merits hearing. The court's computation of the hours through that point that the court is awarding Mr. Thomas is 122.8 hours. Then we have the next dispute between the parties, which is how to look at the penalty phase. And Mr. Eisenberg makes an argument that because Lewis County prevailed on the amount of penalty that was imposed by the court, that means that the court should not award any attorney fees to Mr. Thomas for his work, as that was ultimately not successful. The court finds that there is some persuasive appeal to Mr. Eisenberg's argument. However, the caveat I give to that is Mr. Thomas prevailed on the finding of the PRA violation by Lewis County. Mr. Thomas at that point had to put forth materials in support of his position for penalties. Now, while Lewis County was ultimately successful in the amount of the penalty, Mr. Thomas did receive a penalty. So the court simply went through all of the materials that, all the entries that Mr. Thomas made, and went through all of the pleadings that were filed. And the court is awarding Mr. Thomas a total of 18 hours additional attorney time for the work that he did on the penalty phase of this case. And so, under my calculations, that came to a total amount of attorney hours of 140.8 hours at $250 per hour, which, if my math is correct, is an award for attorney fees of $35,200. The court is awarding the bench copies of $150 that were requested and the $240 filing fee for $390 of additional costs. The court does not find any other cost to be properly compensable. I went slowly through that, hoping that it would be helpful to the parties. Does either party have any questions?
I have a question I'd like clarification on, Your Honor. The Washington State Supreme Court said that attorney's fees, the findings on attorney's fees are findings of fact. As I argued in this hearing today, plaintiffs provided evidence to help this court determine the facts with the evidence, whether it's the spreadsheet or the declarations concerning hours. Lewis County did not provide any evidence to this court of why the hours were unreasonable.
Mr. Thomas, as I stated, and I don't actually view your question as one for clarification. Please stop. I view it as you're arguing, and that's fine for you to argue. It's fine for you to disagree. But I've clearly stated that I went through all of the pleadings. I went through what was charged. And what I am tasked to do is find what the reasonable amount of attorney fees for the work that was done is. and that is the total that I've come to. Mr. Eisenberg, do you have any clarifying questions?
I do not. I actually retract that. You have given a very detailed and specific recitation of your ruling. Do you wish the written version of your ruling to be as detailed and specific as that? Or do you wish it to give a more 30,000-foot look that then sets forth your final answer?
Well, I tend to try to have respect for the work that the attorneys are doing that appear before me. I fully understand that likely both of you are going to be appealing this decision. So, whatever form the two of you can reach agreement is fine with me. I went through and I wanted to be very clear and detailed, so you had that information. And however you both feel that it should be encapsulated in order, I wanted to give you my rationale so you could do so.
Thank you, sir.
You're welcome.
Thank you, Your Honor.
You're very welcome. So the other matters on our calendar today, obviously no one is present in court, and there's good reasons for that. On FPR2 LLC versus the State Department of Revenue, 17-2-564234, that matter had been a joint report.